Good evening, everyone. I'm Bill Rucker. This is China's Emerging Data Protection Framework by Roger Ramirez. There's my citation for it. My motivation for choosing this paper was that I wanted to see what America's biggest competitor on the global stage does differently than the United States and how culture could affect cybersecurity development. I think the reason that China is such an important nation to study is in the realm of cybersecurity is that their ascent to global superpower status has been so rapid that they're able to both look at what other countries have done while also adopting the most modern technology without being dragged down by legacy systems that have been in place for decades, like you'd see in Europe and the United States. Background: China's recent data protection frameworks, the Personal Identity Protection Law, the PIPL, and the Data Security Law, DSL, have become the subject of study by researchers in the United States and the European Union. Because of China's increasing presence in the digital world, they were able to blend European American laws with more modern technologies, not slowed down by legacy systems. 1990s to 2000s. The Golden projects that started during the 1990s that were meant to bring China into the modern era, compete with Europe and the United States, focused on making the government more efficient and maintain social stability. Needed to collect data to do this. Economic value of data soared because of this and the black market. Multi-level protection system. 2007, the Ministry of Public Security, which is the Chinese version of the DOJ, releases this new system to combat emerging cybersecurity threats. Focused on networks and network systems, constructed an institutional and conceptual framework of digital assets. Privacy laws were based on European laws and stopped personal information from being sent out of the country by private companies. Cyberspace Administration of China, the CAC, created by the Chinese government to begin regulation and responding to increasing attacks on digital infrastructure. 2009 outlawed government entities from selling personal information. 2011, People's Bank of China worked with the CAC to protect people's banking information. In 2011, the Ministry of Industry and Information Technology, the MIT, released regulations that included informed consent, obligations to notify authorities of serious data breaches, and prohibited service providers from trading personal information. However, it had weak enforcement mechanisms. Changes began in 2012. The Chinese government began to centralize data and create more uniform data governance, moved away from sector by sector interventions that they've been doing prior, and driven by a rise of illegal data trading in the private sector. Digital economy booms, motivated by the fact that Chinese population that had access to the internet increased from 16% in 2000 to 70% in 2022, mostly driven by mobile phone users. And there was a 100x increase, so 100 times, 100-fold increase in e-commerce between 2011 and 2019. The National Cybersecurity Strategy and Decision on Information Protection created obligations for online businesses to delete published personal information, address-related infringement, prohibited the government agencies from leaking, distorting, or selling personal information, and regulated user-generated content. The Supreme People's Court, which is their version of the Supreme Court, gave power to law enforcement to tackle any infringement of these rules, which increased the enforcement of data-related crimes. Chinese cybersecurity law. The CSL was passed, which would form the foundation of the cybersecurity policy in the Chinese digital sphere. Covered cybersecurity topics including data protection, threat response, and infrastructure protections. Created harsher punishments for organizations with personal information protection, including longer jail sentences and steep financial penalties. Primary focus of the law was strengthening critical digital infrastructure. Also issued rules on organizations outside of China. Chinese cybersecurity law revisions greatly expanded details on personal information data, national security data, economic security data, and data that affected the social stability of China. Establishment of its technical standards and its protection of children's personal information. Issues with enforcement between multiple bureaucracies. So again, not as strongly enforced as they. Commerce law 2018 specifies that Chinese technology companies could use personal information-based targeting advertising. Application Governance Working Group. In 2019, the AGWP was created, combining several Chinese tech leaders, the CAC, the MIT, the MPS, and the State Administration of Market Regulation, to regulate information collection from applications on mobile phone users. Heavily enforced with 2,868 cases prosecuted. 2021, the group began issuing further clarifications, changed what type of information the mobile apps were allowed to collect, primarily focused on fintech operations, stock apps, and user-generated content. Personal Information Protection Law, the PIPL, heavily inspired by the CSL, it evolved with more technical advances that were developing. Expanded the responsibility of data regulations from just network operators to the personal information protection handlers. Combined necessity with consent when collecting data information. Included if your organization was going to export data, They must conduct a CAC organized security assessment before doing so, heavily emphasized on foreign businesses that dealt with China, blacklisted foreign companies that would harm Chinese interests, added provisions that ensured that Chinese law enforcement is not impeded in surveillance activities, allowing them to access data that's important for Chinese national security interests. PIPL attempted to fulfill three different objectives: protect individuals from malicious or improper data collection and use, stimulate the development of the digital economy, and allow for domestic security forces to use data for the purpose of national security. Data security law. Focus was data and its relationship with national security and the public interest. The National Security Council was put in charge of all government data collection, with the NPS and CAC being put in the background. DSL creates three mechanisms for data protection: a mechanism for emergency response, a mechanism for data risk assessment, reporting, information sharing, monitoring, and early warning, and a mechanism for data security review. Focus on data handlers by making them responsible for regular risk assessments and coordinating with national security agencies. Two competing issues was national security and development objectives. Modernize data security through the following strategies: integrating artificial intelligence into public services, researching in data development and technology, investing in the cybersecurity industry, and investing in data trading. Creation of tier system based on if the data was important to economic and social development, national security, the public interest, and the rights of DSL and the PIPL frameworks are putting China at the forefront of data protection. Development of the Great Firewall prevents data from coming into China. Shifting focus on smart vehicles and the transportation industry put the automotive industry in the same pillar as the healthcare and banking industries. Privacy. Chinese definition of privacy is the private tranquility of natural private persons in confidential spaces, activities, and information that they do not wish others to know about. Focused on stopping unsolicited phone calls, text messages, and emails. Chinese Communist Party built their data protection framework slowly, which allowed the internet economy to grow, reflected the belief that prioritizes long-term strategy over short-term gain, and moving forward, the view of cybersecurity will be filtered through national security needs. The standing of the paper is held in high regard by contemporaries. Google Scholar shows the article has been cited 103 times. Very popular when discussing the topic of emerging data protection frameworks. Not as popular when compared to articles that study China's espionage operations. And hosted by the University of Oxford and the Journal of Cybersecurity. Intended, I would have added more examples and case studies that showed why each law passed. Show common attacks and scams the Chinese were dealing with at the time, explore the relationship between the various cybersecurity and law enforcement agencies and bodies, explain why the enforcement laws were so weak, and compare and contrast how the laws in China versus similar laws in Europe and the United States. My analysis of the paper. Strengths. Very informative and easy to digest. Important to engage with articles like this because it expands our knowledge base. Enjoyed the combination of Chinese culture and philosophy and how they played an important role in the development of China's cybersecurity policy. Weaknesses. Dive more into the role of the Chinese Communist Party in the development of policy. Explore individuals who are important to the drafting of bills and see if we can understand the motivations for making the bills they did. Thank you.